Somebody will have to send it out. All board members. Seance. Get me on a Ouija board. But that's what.
All rise.
Thank you. Please be seated. All right, we are on the oral record in 3 cases captioned as the State of Ohio versus Tamara McCoy. 66570, 669-261, and 669-473. The State of Ohio is represented by the prosecutor, Kevin Filiatro. Ms. McCoy is here with the 2 boys, Jay Schlackett and Kevin Kazaki. We are here at my request. I want to say thank you to the participants and for making yourselves available today, especially Mr. Schlackett, as I understand you're in trial elsewhere. Thank you, Aaron. So, Ms. McCoy, what we're doing today is correcting a mistake that I made at the sentencing hearing on September 27th. At that hearing, I did not impose sentences on the firearm specifications in accordance with law. So, as I referred to this in the judgment entry that went out a few days ago, this is a de novo sentencing. Having said that, is the State of Ohio interested in offering to incorporate in today's hearing every argument made by counsel and every bit of testimony, they weren't under oath, but testimony by the witnesses made on September 27th?
We would move for all of that to be incorporated, Judge.
Object, Mr. Caput or Mr. Schlackett?
No, Your Honor.
And is the defense asking that every bit of your presentation be, from September 27th, be incorporated into the...
Yes, Your Honor.
Right, you object?
No.
Right. So everything, Ms. McCoy, that was done on September 27th is going to be taken into account and into consideration here today. Let me make sure that we are working from a common set of assumptions. So, we are here for sentencing in 669-261 1, 2, 5, 9, 11, and 13, based on prior findings of allied offenses of similar import. Agree or disagree, Mr. Filiatro?
If I could have, with me is
I'm
Prosecutor
sorry.
Brad Meyer. He tried that case before the court.
I'm sorry, I didn't notice him. He was sitting unobtrusively at a different table.
Yes, Your Honor, I believe that is correct.
All right, and then can we, well, do you concur or not agree, Mr. Okay.
Your Honor, we agree.
And then in 669-473, we're here for counts 1 and 2, aggravated robbery and weapon under disability. You concur, Mr. Filiatro?
We agree, yes.
Mr. Caprica?
Yes, Your Honor.
Then finally in 666-570, especially considering the stipulations, I believe the most were and findings on allied offenses of similar import, we're here on counts 2 and 4.
2, 4, and 10. That was a weapon under disability on that
Completely forgot that account.
count, on that case. Thank you.
You agree, Mr. Caprica, 2, 4,
I
and 10?
do, Your Honor.
Okay, so, we happen to hear anything that the state of Ohio wishes to add to the material already incorporated?
Your Honor, just briefly as to the firearm specifications, as I know that's what brings us here, as it relates to case 669261, just to be clear, it is the state's position that a 3-year firearm specification is mandatory on count 1, 2, 5, and then I believe it's
9.
9. Yes, Your Honor. In this matter, so there should be, must be, we believe, 4 3-year firearm specifications that have to be run consecutive to one another in any other prison sentence. So we'd ask the court to impose those along with the essentially 8-year sentence that this court had given before on the underlying. We believe that would be appropriate given the seriousness of the offense, the number of offenses, and the fact that the defendant was on probation for defense violence at the time. Thank you.
Anything else, Mr. Meyer?
No, Your Honor.
Mr. Filiatro?
Thank you, Judge. Your Honor, we, with regard to case 666570 on the issue of firearm specifications, we believe that the 7-year firearm specification must be imposed on count 2, and the 3-year firearm specification on count 4. For 570, there are no firearm specifications in case ending in 473.
So, I'm sure Ms. McLeod and her counsel don't mind it, but why are you not arguing for the 7-year spec on count 4?
I mentioned this in my sentencing memorandum. I believe with regard to count 4, the 7-year firearm specification is inapplicable to that count. Under revised code section 2929.14B1FI, the 7-year spec only applies to a felony that includes as an essential element causing or attempting to cause the death of or physical harm to another. Thank you.
So, and that, by the way, that is the reason that Mr. Schleicher and Mr. Caprica, as you know, that we are here, is the incorrect imposition of sentences for the specs. I will tell you, without impairing your ability to either convince me otherwise or object and preserve this issue for an appeal, I think that Mr. Meyer is right that all 4 3-year specs in the 669261 have to be served prior and consecutively to each other. And I agree that the 7 and 3-year specs in the case ending in 570 have to be served prior and consecutively to each other and to all those other specs and every felony count. Meaning, it's my opinion that before anything else is served, Ms. McCoy has to do 12 years on the 4 3-year specs in the 1, another 7 on the 7-year spec for 19 plus another 3 for a total of 22 years on the specs before beginning any felony sentence. That's my position. You're welcome to either persuade me while I'm wrong or at a minimum preserve an objection.
Your Honor, if I may, you had given this a great deal of thought before you came out at the original sentencing, and you made a judgment entry in a sentence that you felt was appropriate to adequately punish Ms. McCloy and consistent with Revised Code 29, 29, 11, 12, 13, and 14. I understand that it has now come to the court's attention that unfortunately the law requires this honorable court to impose consecutive sentences on the firearm. We understand that. But what we're asking, Your Honor, is you could certainly fashion the underlying offenses in a different method so we end up with the same net result. Just because the law requires there be consecutive sentences does not mean that you would analyze what's an appropriate sentence for this 18-year-old or now 19-year-old girl any differently. So we're not objecting to the imposition of consecutive sentences because even though we argued against it, we understand that you are opting for the side of the government and you think that it is required, but we still, right, but we still are submitting that you could fashion the sentence to be in the same amount as you did before, although we still do accept and object to the argument from the state that this was not a continuing course of conduct, and we don't really believe you need to impose all these consecutive sentences. But if you disagree with us, that'll be for the Court of Appeals. But the bottom line, Judge, is you could still give her the same sentence you gave her before, just fashioned differently. Thank you.
So thank you, Mr. Slack. I wouldn't say that I'm siding with the prosecution. I will say that upon reflection and further research and consideration, I have come to the conclusion that I am required to impose that minimum of 22 years on specs prior and consecutively to anything else. So thank you for your presentation. I did offer Ms. McCloy the opportunity for an allocution last time. This is a de novo, so I think I'm required to offer her the opportunity for an allocution this time. And I can't believe I don't remember this. It was only a week and a half ago. I can't remember whether she made a statement, but suffice to say, Ms. McCloy, before sentences are imposed orally here in open court today and then put in writing later today or early next week, do you wish to either make a statement on your own behalf or to present additional information in mitigation of punishment?
No.
Thank you, Ms. McCloy. And was there something you wanted to say, Mr. Capra?
It is, Judge. I would just highlight, Judge, and I concur with Mr. Schlackett concerning the previous sentence that you gave. Judge, I believe the previous sentence had Ms. McCloy doing approximately a 54-year-to-life sentence. And I would highlight, Judge, she was 18 years old, obviously, at the time. Currently, the way she is sentenced, she will have to be 72 years old before she's even entitled to go to the parole board. So we would strongly, and as the court's aware, the parole board oftentimes will extend a person's sentence from their original parole hearing. So her best bet right now is 72 years. She'll be 72 years old, and the estimated life expectancy of a human being in the United States is somewhere between 72 and 76. So your previous sentence gave her some glimmer of hope of getting out and maybe working towards becoming a better person and having a goal and a potential light at the end of the tunnel. Anything over that, Judge, would be basically a life imprisonment without parole. So we would certainly ask, and I agree with Mr. Schlackett, that this honorable court fashion a sentence that is no worse than the 54-year-to-life sentence currently imposed. Thank you, Judge.
Thank you, Mr. Capricky. Once sentences are imposed orally, I will advise Ms. McLeod of post-release control, of her right to appeal, of her jail time credit, and of the applicability of so-called Reagan-Toke sentencing laws to the felony ones in these several cases. So that will be done in a few minutes. Other than that, is there something else that Rule 32 obligates me to do at a sentencing that we haven't either covered already or I'm about to cover with those things and with the imposition orally of sentencing?
The state is not seeking restitution in any of the cases, and I don't recall whether the court waived fines and costs last time, but I think those would be the other items besides PRC and Reagan Tokes in this case. Thank you.
Thank you, Mr. Filiatro. One moment. So, Ms. McLeod, having considered everything presented both on September 27th and today, having considered all the sentencing laws of Chapter 2929 of the Ohio Revised Code, and having considered all the evidence, of course, presented at the trials, in case number 669261, you'll remember that's the one with the co-defendants on count, on count one, the aggravated robbery, you're ordered to serve 6 years at the Ohio Reformatory for Women. On count 2, 7 years. On count 5, 8 years. On count 9, 8 years. On count 11, the weapon under disability, 12 months. And on count 13, the firearm, improper handling of a firearm, 12 months. In case number 669473, the Christmas aggravated robbery of Rafael Hernandez, on count 1, you're ordered to serve 8 years at the ORW, and on count 2, 12 months at the ORW. In case number 666570, involving the aggravated murder on New Year's Eve of Shane Bartek, for count 2, you're ordered to serve a term of life imprisonment without first parole eligibility until after 25 years of service. On count 4, you're ordered to serve 8 years. And on count 10, the weapon under disability, you're ordered to serve 12 months. All, excuse me, all of these felony sentences are ordered to serve concurrently with each other for the felonies themselves, the crimes themselves, not talking about the specs, which I will in a moment. So concurrently with each other. So really it's a single concurrent prison term of life imprisonment without first parole eligibility until 25 years. On the firearm specifications, you are ordered to serve what was already outlined orally, but in 669261, 4 3-year firearm specifications. In 66570, 1 3-year specification on count 4, and 1 7-year specification on count 2. All the specifications have to be served consecutively, meaning one after the other, and those are mandatory. The amount of years on those several specifications is, if I have calculated it correctly, 22 years. Agree or disagree, Mr. Filiatro?
The 22 years on the firearm specifications is a correct calculation.
Agree or disagree? Not that they're required to be imposed, but the addition is correct, Mr. Schlenk.
We object to it, but we agree with your math.
So those 22 years will have to be served first. Then you will begin your life sentence and the sentence on all the other counts. What this amounts to as a practical reality is a sentence of life imprisonment without first parole eligibility for 47 years. You have a credit to date, I believe, of, it's in the range of, I think it's 280 days as of today for time served January 1st through today. It's an easy calculation to make. I may be off by a day or two, but the judgment entry coming out of this hearing will include that credit. That's obviously, essentially 10 months. So basically, your first parole eligibility after today comes in 46 years and 2 months or something like that. Court costs are waived. The state of Ohio has not asked for an order of restitution. Now, I do want you to know that all of the aggravated robberies here, the first-degree felonies, are qualifying offenses, qualifying felonies of the first degree under revised code 29.144, also referred to as the Reagan-Toesley. So, on those felony sentences, it is rebuttably presumed that you will be released upon the expiration of a single 8-year term. However, of course, that 8 years would come after the 22 on the specs. And even if your prison terms on the felonies themselves are ended after the minimum terms imposed by this court, you would still be kept in prison on the life sentence until that first parole eligibility, if not later. But back to the felony sentences. So on those sentences, as mentioned, it's rebuttably presumed that you'll be released after, or you'll be done with the sentences after 8 years. And as mentioned, after the specs. But the Department of Rehabilitation and Correction may rebut that presumption if at a hearing held under section 2967.271 of the revised code, the department may specify determinations regarding your rehabilitation, your threat to society, your restricted housing, if any, and your security classification. If the department at the hearing makes those determinations and rebuts the presumption that you'll be out at the end of the minimum terms imposed by this court, then the DRC may maintain your incarceration, keep you in prison for up to an extra 50% of that time, which is to say up to an extra 4 years on those felony sentences. If, however, you have not been released or be considered to be done with your service of the sentences on the felony counts, not including the aggravated murder, prior to the expiration of the 12-year maximum prison term, then you must be released or be considered to be done with those sentences. Additionally, the life sentence is not subject to post-release control. That's subject to parole, and then the parole is at the discretion of the parole authority. It may or may not be granted, but the court has nothing to do with it. However, for the felony sentences, when you are released from prison, it is required that you be on a mandatory minimum of 2 years up to a maximum of 5 years of post-release control, called PRC. PRC is quite similar to parole, but it's not exactly the same. So during the time that you are on PRC, you will have to report to and be supervised by a parole officer. During that time, you'll have to abide by whatever conditions the parole officer places on your conduct. If you fail in that regard, then the parole officer has the authority to return you to prison without bringing you to court for a maximum of 4 years, depending on how many violations you commit and what they are. Also during the period of PRC, if you should fail to report to the parole officer as ordered, then the prosecutor may institute a separate prosecution under the criminal code for a crime known as escape, where you face additional prison time if convicted. My last advisement to you about PRC is that if the time should come when you're on PRC after the prison terms in this case, and then you commit a new felony, when being sentenced for that new felony, you can get as a punishment for violating PRC an extra prison term equal to the greater of 1 year or the number of years then left on post-release control. You are advised that you do have the right to appeal your convictions and sentences in all 3 cases. And if you are unable to pay the cost of an appeal, then you have the right to appeal without payment. Furthermore, if you're unable to obtain counsel for an appeal, then counsel will be appointed without cost, and the documents necessary to an appeal will be provided without cost. I do ask Mr. Schlackett and Mr. Capricky if an appeal is contemplated, instead of asking the trial court to appoint appellate counsel, if you would be kind enough to perfect the appeal under, as I recall, Rules 3 and 4 of appellate procedure, and then to ask our Court of Appeals under Local Rule 46 if it would appoint counsel, either someone you recommend or someone that it chooses of its own volition. My reason for that is after the trials here and the imposition of sentences, I think it's best that I not be involved in selecting appellate counsel, as often happens in cases of all kinds, but usually less serious cases. At this point, Mr. Filiatro, I believe I have complied with Rule 32, but I was mistaken about the consecutive, so I'll ask you, because if I'm mistaken about this, you're going to have some extra work because you'll have to re-prosecute after an appeal. Do you believe I've complied with Rule 32?
I believe that you've covered everything. The state would like to object that there are not separate sentences for separate crimes, although I think that there's no real ability for us to appeal in this situation. But I would like to put that on the record.
So on that, what I'll say is this. You will recall, and I'm sure you will recall, Ms. McCloy, that at the September 27th hearing, I made findings justifying consecutive sentences for, essentially for different acts and different crimes. And I made those findings because I believed that they were necessary. Having said that, that was also when I was mistaken about the specs and the amount of minimum prison time before beginning the life sentence, because there are, the specs are consecutive to the life. So back a week and a half ago, I felt that there should be some additional time than just concurrent felony sentences before beginning service of the life sentence, which was ordered consecutively back then. Now, though, I would say that the sentence from last week it's a little different. It's slightly less, slightly less time until first parole eligibility. But it is, I believe, essentially indistinguishable from last week. So that's a reason I didn't make findings justifying consecutive sentences today, because I didn't feel consecutive sentences were necessary to get to more or less the same place that I used consecutive sentences to get to last week. I do recognize the figure is different. I think it's different by a factor of 3 years, not 4, but I could be misremembering. The point being, while it is true that, for example, all the aggravated robbery victims, including, of course, Mr. Bartek, those sentences will be concurrent. In the end, Ms. McCoy, for all of her conduct, is going to serve a minimum of the 47 years, and knowing how the parole board operates, it's bound to be, I dare say, quite a bit longer than that. I'm nearly certain it's going to be longer than that. I'm pretty certain it's going to be quite a bit longer. Having said all that, I don't fault you for making your position known, but that's the reason that why I'm doing what I'm doing today, which is not exactly what was done the other day.
Understood. I do believe, though, that you were correct in your findings for reasons for consecutive sentences, and I don't believe that those reasons have gone away. And that was my point in standing here.
I'm not sure they've gone away either, but I think that the need to make them, in other words, I think we can acknowledge as a practical matter that those reasons justifying, statutory reasons justifying consecutive essentially exist, but as a practical matter, it's not needed to find, as a matter of fact, that they do exist to get to a sentence that I believe is ultimately just.
Thank you.
So appreciate that. Anything else, Mr. Meyer?
No, thank you, Your Honor.
Anything else, Mr. Slacker, and or Mr. Capper?
We object to the rating Tokes imposition, Your Honor, and just so the record is clear, you did impose a separate sentence for separate crimes. You just ran it concurrent, which is within your discretion.
Well, I knew what he meant, and obviously so did you. So I have to say that I apologize for my error of a week and a half ago. I thought, though, the inconvenience of coming back today would be much less than the inconvenience of returning after a review. So, Sheriff,